Good evening, everyone. Thanks for joining our monthly law labor update March 22 and conversation with IR Gurus. We would be having Mr. Padma Kumar of St. Gobain as our IR Guru for this month, and Mr. Swaminathan of Blue Dart Aviation would be anchoring the program. So before that, we'll just start with our update for this month. There's just one amendment that has been come about this month. It is under the Andhra Pradesh factory rules. Basically, they've tried to take many of the registrations online, and they are providing for a single desk portal wherein the license will be issued within 7 days automatic. If it's not issued within 7 days, it becomes automatic. And they provide for a 10-year block period license. So if for 10 years, you could take a license if you want. So that's the substantial change that has come about with a single desk portal that they're trying to take the entire provisions of the Factories Act online. On circulars and notifications, the Madhya Pradesh government has done away with opening and closing hours for restaurants. So it could be that they could be even open for 24 hours in a month, in a day. Punjab and Haryana government has made amendments to the Shops Act, whereby till date, women employees were not allowed in night shift. So now the Punjab government has brought in a scheme. There is a provision under the Act to exempt and make certain schemes, and using that same, it has brought out a scheme where employers can apply for engaging women in night shift. And there's a host of conditions that have been given under the scheme. If and once the employer is willing to comply with these conditions, women can be employed in night shift in shops and commercial establishments. The Maternity Benefit Act, there was a technical issue as far as ESI for women employees who are availing maternity benefit. In the sense, because of enhancement of the benefit from 12 weeks to 26 weeks, there was a non-contributory period that comes in. So, there are two, April to September and October to March are considered as two contributory periods. And there would be a chance wherein the women employee may not contribute at all for 6 months because she was in the 26 weeks of maternity benefit. So to clarify that, a notification has been made and the rules have been amended to that effect, so that even if an employee avails 26 weeks of maternity benefit, she will still be entitled to the provisions of the benefits of ESI in the subsequent benefit period. The quiz segment for this month, the IR code prescribes a time limit within which domestic inquiry should be completed. The question to you is whether is it to be done within 45 days, 90 days, or 120 days. Please do put in your answers in the chat box. In our Across the Globe segment this month, we are looking at certain laws in Japan. To start with the leave benefits in Japan for childcare and family care. The employees are being given leave benefits for childcare till the first birthday of the child, and the mother can even avail up to the second birthday of leave. It's available both to male and female employees to take care of the children up to the age of 2. And apart from it, to take care of your other family members when they're sick or injured. They also provides for short-term leave and long-term leave. These are quite progressive leave benefits that are there. We just thought we'll share it with our viewers so that they could consider something similar to this in their organizations as well. And while we are concentrating on prevention of sexual harassment, Japan is looking at prevention of power harassment, which is something again we thought is very unique, and we have put that in this month's global coverage. If you look at the types of harassment that they have contemplated as power harassment, so physical abuse, assault or injury, mental abuse, a host of things. It's actually a 2019 amendment that they have brought in. And even excessive questioning on private affairs is also considered to be a power harassment. So, and employers are to take steps to measures to ensure that such kind of harassment is not there at workplace. So they need to have a mechanism by which they should be able to control these kind of power harassments. So it's something very unique. We thought that we not come across, or when we are concentrating on sexual harassment, they move to the next of power harassment. In the knowledge corner this month, we are looking at dispensing with domestic inquiry. The standing orders normally require you to hold a domestic inquiry. There have been cases where the Supreme Court has held, yes, okay, given the circumstances, the employer can dispense with holding of the domestic inquiry and proceed to terminate the employee without holding a domestic inquiry, even though the standing orders mandates. So this is one such judgment where they have held, yes, you can do it. It is not that you have to hold a domestic inquiry in all circumstances. In a case of long absence instance in the bank, there are already 2 previous instances where the employee had been, inquiries had been conducted, and it was the 3rd incident. And in such a case, the Supreme Court held there was no requirement, more because the absence is borne out by records, documentary records were available to substantiate the absence. But at the same time, if you were to terminate an employee without holding domestic inquiry, the burden shifts on the employer to prove the same before the labor court. So if you were to terminate somebody without holding a domestic inquiry, it is on the management to prove it before the labor court. So that burden is on the employer, is what the Supreme Court says. It's not that the employee needs to start. In fact, the evidence itself starts with the employer adducing evidence before the labor court. And one more requirement that has been laid down is that why is the inquiry being dispensed with? Should be recorded by the disciplinary authority. Normally, therefore, when an order of dismissal is passed without holding a domestic inquiry, the reason as to why the authority feels that inquiry cannot be held or is not required should also be mentioned in the order of dismissal. These are cases that arose under the Shops Act, both under the Tamil Nadu Shops Act. Similar cases, question came about as to whether the employer can terminate without an inquiry. Yes, the Supreme Court as well as the Madras High Court has said, yes, you can. And whenever it is done before the authority under the Shops Act, the employer can prove the misconduct. That is what the Supreme Court has held, and the Madras High Court has also followed it in the subsequent case. The Know Your Courts segment this month, it's about building construction workers. While on one side, we are looking at ensuring that inclusiveness and bringing in people. At the same time, on safety aspect, the code provides that if a person has a defective vision or is deaf or has a tendency to giddiness, such persons would not be employed in building construction, as he could not only pose a threat to himself, but also to other employees in the site. So a specific clause has been included to this effect under the Occupational Safety Health Code. We recently had the Tamil Nadu budget in which the government has allotted 2,400 crores to ITIs to train the youth and skill and equip the youth. We thought it's quite a substantial amount that the government has allocated. And another one is where the government of Karnataka has exempted industrial establishments in SEZs for a period of 5 years from the Standing Orders Act. Initially, the exemption was only with regard to IT industry in Karnataka. Now it's been extended to SEZ. There are 32 SEZs in Karnataka, and here they don't need to, the provisions of the Standing Orders Act will not be applicable. But there is a specific mention in the notification that they would, however, need to ensure the compliance of the POSH Act. That doesn't go away, even though the Standing Orders Act may not apply. This month, we have started with a new segment, Lex Posh, to deal with POSH-related queries and case laws. We found an interesting case coming out of the Kerala High Court. There is a society called the Women in Cinema Collective. It's a society, registered society. They wanted the government to constitute a committee, the internal committee for receiving sexual harassment, or rather they wanted the Malayalam Movie Actors Association of Malayalam Movie Actors to form a committee. The High Court found that the Association of Malayalam Movie Actors did not have any employer-employee relationship with the artist who are its members, and hence held that the association doesn't need to form the committee. Basically, it is not an employer. But at the same time, it also observed that each film unit by itself will constitute a workplace, and held that each film production units will need to constitute an IC. So with those directions, these petitions were disposed of. But it's an interesting thought on saying that the association is only for the benefits of the members, and it's not an employer body, and therefore the question of formation of internal committee would not arise. Moving on to our case law segment, we have two cases. This is a case where an employee had worked for nearly a long period of nearly 8 years or so, 2,778 days, and he was terminated. He approached the civil court, and the civil court granted him relief, saying that his termination was in contravention of the provisions of the ID Act. Supreme Court once again has reiterated that civil courts have no jurisdiction when the ID Act is concerned. It's only the labor court which will come, and not the civil courts. The next case law also comes from the Supreme Court on the Employees' Compensation Act. The question is, from what date interest is liable to be paid? The High Court had held that when the commissioner passes an order, 1 month from thereafter, the 12% interest is leviable. The Supreme Court has held no, it is from the date of accident. So from date of accident, the employer has 30 days. And if he has failed to pay it within 30 days from there on, the interest will start from there. So that is the finding given by the Supreme Court. So your interest under the WC Act is 30 days from date of accident, and not from the date of order passed by the authority. We have the complaints for the month of March 2022. Nothing specific for this month. We would be sharing this PPT, and you could have a look at what are the complaints is to be done. The answer for your question under the quiz was 90 days. I find that many of you have replied to it in the chat, and many of you have also got it right. So with that, we will conclude the update for the month of March 2022. We hope to see you on 30th April at 4 p.m.